No, it went through. It finally did. No.
All rise. The Court of Appeals for the 10th District of Texas is now in session. God save the Constitution and this honorable court.
You may be seated. Good morning and welcome to the 10th Court of Appeals holding its oral argument session on the Sam Houston State Campus in Huntsville, Texas. We are glad to be here. We're glad that you all are here. And I've got a few announcements. I apologize for starting late. That is not the norm for us, but we were having technical difficulties. For some reason, YouTube did not want to live stream this session. So I'm a bit delayed in starting. So I'm going to kind of cut my initial remarks short. I do want to say thank you to Mike Yawn for coordinating, hosting this. We have an honored guest with us today. Amy, where did you go? Amy, third row back here. Amy, and I'm going to get her last name, Salazar, is the Assistant Provost for Student Success, and we are pleased that you are here today, and thank you for your support. We appreciate the support of Sam Houston. As I was telling Amy before we started, I was graduating from Sam Houston State in 1978 when the foundation for this building was poured. In about 2011 or 2012, Mike Yawn invited us to come here and hold oral arguments. I remember when I stepped through those doors at the back and looked at this facility, and I thought, how absolutely amazing and wonderful for the university to have this type of facility on campus. When I saw the foundation, I did not see a courtroom. All I saw was concrete and rebar. And so to see it then, 30 years later in its finished product, and they've just had a substantial upgrade on some of their video and sound equipment in here. Amazing facility for y'all here on campus. 40 years. Matt tells me it's 40 years. My math's not so good, but then I'm trying to, reduce my age there. And so that Didn't work. Thank you, Matt. Appreciate that. It is really great to be here. We appreciate the opportunity. The reason we're here is so that you all can see what one part of one branch of your government does. This is an appellate courtroom. I emphasize that because these are real cases, real parties, real issues at risk here, both life and property. And so do give respect to the individuals that are making the arguments on behalf of their clients. If you leave the courtroom, I know that some of you will need to leave at about 10:50 for your next class. That is acceptable. We would ask everyone to stay pretty much in place till at least 10:50 though, and we'll get through as much of the arguments as we can prior to that. Two things different about this than what you would see if you came to watch an oral argument in our courtroom in Waco, Texas. The first is that we ask the attorneys to turn to you as the audience, spend 3 minutes of the oral argument explaining to you, putting their case in context before they turn to us and make the legal arguments. They get whatever range of topics they want to talk about, but we basically ask them to talk about either the facts or the procedural history that will put this in context so that you will understand the legal arguments that they are going to then make to us. The other thing is we normally don't allow photographs at any time once we're in the courtroom. If for some reason you want to do that, that's fine. We would ask that you not use a flash if you're going to do that. These arguments are being live streamed on YouTube. They will be archived on YouTube on the court's channel. And I'll tell you in just a minute how to find that. Also, we live in a society of instant gratification. If you are expecting to see the court's opinion today, you are going to be disappointed. You will not see it today. You may not see it for some period of time. After we leave here today, we will go back to our court and chambers back in Waco. We will talk about the case. We will do further research on the case. We will talk about the case amongst ourselves. And then one of us will write an opinion on each of the cases that are argued today. In doing that, you won't know when we are going to issue that opinion unless you get on the court's case mail and monitor the cases that you're interested in. You can do it to as many cases or as few cases, but in the pamphlet that has been distributed, there is a way for you to, it walks you through signing up on case mail. Every time an order or something happens in that case, we may ask the parties to file post-submission briefing on an issue. When they file that brief, it will be entered in our case management system. You will get an email notification. You can go and then look to see what that brief says. You can also review the briefs that have already been filed if you sign up for go to that case management system. When the opinion is issued, whether it's a majority opinion, dissenting opinion, whatever, when the opinions from the court are issued, those opinions will be posted on that case management system. You will get an email. You'll be able to see what we have decided in this case. If you don't terminate your email connection for that case, every time something happens in that case, you will continue to get emails. What could happen later? A motion for rehearing. They may file a petition for review with one of the state's high courts. First case is criminal. It would go to the Court of Criminal Appeals. The second two cases are civil. They would go to the Texas Supreme Court. You would continue to get notices in those cases as long as that case is active. And so I would encourage you to do that. We've got some other elected officials here today. Tracy Sorensen is County Court at Law Judge here in Walker County. David Marmon is in the back. He is a district judge, the 12th District Court here in Walker County as well. If you get picked up for DWI, you're going to see her. If you commit some other more heinous atrocity, you might see him. So don't do that. They're good people, they're nice people, but you don't want to meet them in a professional capacity in that way. We appreciate somewhere back there in the back is Amber and Kenneth providing security for today. And it's a necessary evil these days, and we do appreciate them being here to take care of us. To my left is Steve Smith. He is the newest justice on the court. Anytime you see a court of appeals, the judge to the right of the chief justice is the one with the most seniority on the court. That means Matt Johnson to my right has served on the court longer than Steve by about 8 months, but it's still 8 months. If it had been a day, Matt would still be to my right, Steve would still be to my left. And I've been here forever, but it is an elected position. And if I only had started just yesterday, I still have to sit in the middle. So that's the chief justice slot. It is an elected position, just like these two positions. And so I will call the docket now. Gentlemen, did I forget anything in my rush? Okay. I do have to tell you all the mics are turned off. I should have been using my mic, but I did not. Did anyone want me to repeat what I just said? Okay, not going to do it. Did anybody have trouble hearing what was said? Mike, was it okay without the microphone? Okay. I will have the attorney, I think Ms. Rogers is going to be the first one up, and I'll get her to turn the mic on at the lectern. At this time, I'm going to call the docket for the morning cases. The first case on the court's docket. What I would like is an announcement if you're ready, and if there are any preliminary matters that need to be taken up before we argue the case. First case is Craddock versus State. Thank you, counsel. You may approach the table. And for the state? Okay, y'all may come up to the tables, and Counsel Rogers, when you get to the lectern, there's a button right below the microphone stem. If you will hit that, you will see it turn red, and it will, you're good to go. Yes. The next case on the morning docket is, and I'm going to, we talked about this yesterday at pre-sub. We have two different spellings of the name, Gantabin and Gantabine with a G. Does the name have a G on it or not? I take it that has no G on it. But not at the end. Okay. Gantenbein versus Lacey. All right, and you are ready? And you are Denton Lessman. Okay. Okay. Thank you, counsel. And y'all know we don't track time. Whatever y'all decide to have ever it's split, y'all will have to work that out amongst you. Okay. Counsel, you may approach the lectern and proceed with your 3 minutes when you are ready.
Good morning, everyone. My name is Morgan Rogers.
Morgan, I'm going to interrupt and ask you to step on this side of the podium and kind of stand the microphone up so it can pick you up. There you go. It'll work from there. That'll be fine. Go ahead.
Now, the state has The right one is the beginning of the right. And what happened is looking. So I tried. For a second time. And neither. Mr. Hadid. Finally, Mr. Hadid, he didn't.
Council, that's the 3 minutes, and if you'll turn and now make your arguments to the court.
There are, I believe, 15 distinct issues. The briefing covered about 230 pages, so I do recognize. Instead, I'll focus on the two issues that I see. That is, and that is something I believe that it is broad. These two issues revolve around himself and the failure of the person. The state and proper and consider that when it received conviction of entity to and character, to be clear, Mr. Hadid's medical condition. Two felony elements and it is currently on hold for so 5 years. This is not advantage of this partner information that witnesses can't do and the state certainly never raised any kind of for any period that some evidence present day. The city players evidence is not admitted that was raised, nor was it admissible for any other.
But counsel, as you laid out, one of the elements of the offense of a felon in possession of a firearm is that the state has to prove that they are a convicted felon. Why is the offense not admissible for that purpose? And why should it be limited since there was not a stipulation?
It should be only that he had in mind. It was not admissible. Guilty of this offense, committed a murder. That's true under DS and it's not purposes, but very low. murder conviction, so it was all under 619 analysis. So it was portfolio under the counseling rights. And in addition to that, the state would have the burden of trial.
Two questions. You say it's over 10 years old. Do we measure it from the date of the conviction or whether or not it is the date of the final, that it's final, and the impediment, if you will, the consequences of the conviction is final? And were there any objections to the admission of the felony conviction, the judgment, the fact of what it was for? Were there objections to any of that by trial counsel?
Well, is it your position that, I mean, normally these prior felonies are proved up with a penitentiary packet. Is it your position that the actual offense itself should have been redacted from the penitentiary packet in order to prove the prior or prove some other way? And I'm just curious how else you think you would have preferred that it be proved up.
I don't think any issue with the case. I think it's sure that the state possession of the firearm.
And isn't the 10-year limitation you referred to once they're relieved of all obligations under a conviction, which would mean 10 years after they get off parole?
I think the judge's question was, when could the prior felony conviction be used for impeachment purposes? You had argued that it could not be used because it was older than 10 years, but he was still on parole for that felony. But he was still on parole, so the disability related to it was still pending. In other words, he was still on parole, and therefore the offense could be used for impeachment purposes.
I disagree. And so that this impeachment purpose that it was not. But even if it wasn't. And so the issue is that when the state made these arguments, they were making arguments as evidence of nothing. They gave the trial counsel perfect.
Well, did the trial counsel ever ask Judge Longley to limit the jury's consideration of claims such as, do you consider this only as a predicate for this charge and for no other purposes whatsoever?
Well, I cannot say that the record is something that's very far. But the issue is as to when it goes to whether or not the court should just include it. That's it. And because it is required. This trial court, not only did it not include limiting instruction, that President considered. That money, well, the trouble with it was, it included a jury charge. I told the jury that it included consider it as running. As anyone noted. Without any carve out. Similar to this, and it was here, because it is not. The murder conviction was not given any other. So the thing is the purpose, and we're doing the record that the trial court not extended to an including instruction. And this instruction that was applicable to the murder. A way of trying to leave the drugs, other firearms, and so the court was trying to do was instruct the jury on how to full tracks that. So despite the charges not being admitted as a for the purpose of the state told the jury to consider Mr. Fox's character for truthfulness, for generally, all of and fact, the state acknowledges in response that it did. In his response, that it has to do so because Mr. Fox and that it was but they made this argument so despite never and they don't ever try to blame the
But if it was not limited to a particular purpose at the time that it was admitted by a limiting instruction requested by counsel, can't it be used for all purposes?
when it was admitted, it was admitted after the court that the state will not have to approach to admit the documents because they can or the purpose of proving the argument.
But even with that statement by the court, wouldn't defense counsel still have to request a limiting instruction if he did want it limited for a specific purpose?
And Robert did he did not specify exactly.
Did the trial court deny that request?
In its general that said it is considered even but with the city agent, they repeatedly referenced current decision. And they said things like, as he said, in the state's we have all the deputies and then we're the defendant, who are the local. And they have their two serious chance anything that the court could have instructed that you could be total concern. Right? This is in fact the Barber case, the circuit case, where, the court indicated this type of argument was fundamental. And the court held it's fair and work basis, but in Barber, that is actually harmful than what happened. In Barber, it's the very good thing. Here, the jurors just before the state sit up and jurors had just heard on the agreement that the jury was able to consider any bad act.
Counsel, you've made reference to a case, I take it was a Fifth Circuit case. Is it cited in your brief?
It is.
Garber.
Okay. Thank you.
The issue is here.
Timbers.
And it doesn't matter how overwhelming the case was, right? The conditional is. I recommend this. Prejudicial. And now, I can't think of the prejudicial thought. This was a prior murder conviction by. In a general. As soon as the jury hears that, and the state capitalized. Because granted, if this was not a objection to the prior case, the jury never would have. They never would have heard it. It's far too prejudicial. But they did hear about it because of the elements of the state capitalized. And it gave us. That was already on the same. How did you do this today? Yeah. But they went out and made it consider this recommendation for any of the case because of the state part of it. And it's made people that first. And because it did, before the state stuff they are to use for a purpose that is not illegal. And I can't think of a situation more than this one. I can't think of two offenses, a prior conviction that is more prejudicial than a murder conviction. The attorney is okay. Any possession of a firearm. Now, we need to be in the and we cannot be sure that it's not content. Especially when they were already predisposed or being made that connection.
Thank you, counsel.
Good morning. My name is this will be decided for the third part of during the consensual injury, one of them be found open to Anybody know about doing this? then from, and, well, again, certainly involved in the police department. He's on the trial or wasn't. He's on. I told him, thank you, say this. And I didn't know what I was doing. It was pain when I was he's like, we stay, they want to be able to. And it's probably going to be cage. So I was in the third year, working division. And then the office, because it's all person. From the principal, we were allowed to. One is already addressable for the issue here, and that is this making different. Because they had proved that it's part of the norm of the office. And so you put it in judgment, you put it in the environment, you put it in the the contribution. They don't really talk about it. Then have been released on the roll of 2014. So they already as the actual condition made, they were on the roll of that is what we had, even though my can still for the office to be in his house. He testified very strongly that he was not to do. And that he was not to do the office commission to go to the state. And then he told him it was legal for him to the office to be in this. And all of this profession, I was both. And I didn't know how. Because that's and some work. So and eventually and be innocent. Therefore, the church. Now, he's probably identified his own church. The thing to do here, making the environment. And he's 25 years in prison. And then he was released in 2014 and he was to that. Then he was identified and used that for as the basis of his investigator, as he was saying, only he could allow things that he can open up and say, the union is government. So the defendant's testimony went straight to the heart of the matter that because I made convincing murder, For the medical issues. My leadership would be big step forward, and then that's no one minds. Yeah, I remember reading the main brief. Or there was any part that says. The underlying felony used in an unlawful position. This probably in the case of building the 2017 Hoffman case, kind of a sub issue where they complain as in the testimony was ineffective, not and so living part of the condition. And I think to go around, there's no court. Should be able to, in this situation where conviction. So, yeah, and it's right to issue. And you need that in the period, he did not voluntarily consent. This is generally different from the situation where a defendant is taking a stand. And it's going to be simply a possible inventory. And reveals to be capable. The trial version requires to be another. And beginning with rising the fact that these don't even not step over this. That was very positive. So for that reason, don't worry about it. Hold to not give them to construction. And comments was not ineffective or not reflecting or not reflecting. And then frankly, it's funny when I'm doing close to market. Little confused, to be honest, in the problem. And if we can be her problem, we someone that was never seen. We have to not extended. That's what it is. Then, raising the fact that he's a big part of using that as a testing tool to use Gino.
Council, within about the last month or so, the Court of Criminal Appeals issued an opinion that said something to the effect, it doesn't matter if it's one gun or three guns, a conviction for a felon in possession of a firearm, the state only gets one. It was a double jeopardy case. Does that case have any impact on this case, since there was a shotgun that was also found, 22 rifle too, although there's been less discussion of that? And would it, if so, would it take the issues of consent around the opening of the safe and the discovery of the 38 pistol, the revolver, out of the case?
That is one issue that was dealing with being multiple conditions from multiple weapons. And the second
So the indictments did specify which firearm? Okay, then it is very different than the other case. Thank you.
Mr. Howard, let me ask you this question about the, what I want to call the drugs paraphernalia. How in reality is it contextual to a felon possessing a firearm?
So as you remember, back in this case, we were told that the officers who had been given consent and enough to look to you. And he claimed you, not only because there was, if the Americans walked down, he saw a law paraphernalia on the table. And so at that point, we had not only drugs, that because the problem was you didn't want to paraphernalia. So that one of the defendants said, regarding everything. Now, this says, let me say this, before the government is they already heard prior testimony from them that the drugs were in his house. They had already heard seen in plain view of the box. And then as to the weapons, those weapons in this show what his defensive strategy, because the additional weapons can be said are so to provide to explain how we're going
I understand your theory.
All right.
and
Thank you, counsel. Hold.
It's nothing personal.
Yes, they've got to go to their next class. I don't know that we've ever had that many leave all at the same time. For those of y'all that have not seen this done before at Sam Houston, I don't believe I've ever had that many students leave after the first case. So, I mean, this is shocking even for us. But Counselor, you may proceed with your rebuttal.
Whatever the premise is, and the issue in the case is usually injury. The issue that I have is that essentially skirting the court date to make their argument. Typically, I think it's only come around. Never. They come in see. They have to admit it, they have to question the defendant about the concern. But so the ground for the never me. Make a decision that did it, make that decision, say that they were. Just a standard question. Into what? the we're getting older. And we aren't even having. Because this commercial evidence only. It's not. It's what areas to get. So I would say. That might. And because the administration, I know you're gonna. The same thing.
More questions? Thank you, counsel. This case is submitted and y'all are excused. Come on up, counsel.
He needs to give us 3-minute deal.
Don't know. Let's, counsel, wait for a minute and see if we have some more audience. Is that it, Mike? Okay. I got the same text. I think our clerk got the same text. I don't know what can be done. The only thing I can think of is that possibly we might turn the microphone off and speak very loudly or move it away. So that, apparently it's out there. We're fine up here. We can hear it, but it is a Counselor, why don't you just do a test on this side? Don't get so close to the mic and see if it picks you up. Mike, did you hear that? We're having some trouble. It's the audio is not particularly good on the YouTube from that microphone. I don't know if it's. You can hear it. Okay. Go ahead and turn it off. And Amber, I'm going to count on you to give me the thumbs up or the thumbs down if you can't hear counsel. And when he turns around and is making the argument to the court, if you give me a thumbs down, I'm going to ask counsel to turn the microphone back on. But if y'all can hear, then we're going to proceed without the microphone, and hopefully that will alleviate the problem. We have no problem hearing even the regular audio, without the microphone. So, Councilor Lessman, you may proceed.
This case is how homeowners who bought their home in March, and before they were buying their home, they had a conversation with a neighbor during one of their inspections. Next gentleman said, "I'm across the street," and then met him in the street. During this casual conversation, they talked about that this home was very good. It's 7 bedrooms, 7 bathrooms, and that the reason for them not is that the two couples in mind, been together for 35 years, began to move in with elderly mother who really didn't have medical issues, but she was older and getting elderly needed some assistance. You know, period. So, what they had experienced, they lived about 2 miles apart. And when the mother would call the daughter and say, "I need some help," she had to drive a half an hour to go over there and go back. So the women during this conversation, what are you gonna do with the extra bedroom you got? Oh, well, we may look at renting out. So that really comes down to the decision of possibility of what to do with that. So the neighbor and the neighbors, that particular neighbor and some other neighbors for the television in this case was plaintiffs. They knew that the purchaser, they knew that because the plaintiffs, television was actually owned for the bank. And so they knew that they had moved in. I mean, but everybody knew that they had moved in. This is a 30-year-old house that hadn't been updated, and there was talk of there's going to be a lot of things. So even before the new property owners moved in, 4 months later, in June, beginning of July, the neighbors run to a real estate agent and have a letter sent out saying, "Hey, look, we will let you know there's some deed restrictions. Deed restrictions in the part of the deed, they provide rules for a physical. So for the use of the property and in styling of the property. And if there are these deed restrictions which limit the use of this particular property, and that's really the issue of this case. These restrictions, what's permissible, what's not. What the trial court was, the whole trial was about, and basically, here what we've got is we've got property owners using their property with extra bedrooms and the law, which will hear the Supreme Court case in 1960.
Council, let's hear about that Supreme Court case. You may proceed. No, to us. Yeah, you're over your 3 minutes. I thought you were about to wrap it up and then you started down another path.
Yep.
So.
Judges, Mayor, Principal, Council, we briefed, we'll rely on briefing to y'all. There's a lot of issues in this particular thing. We had some very, very long briefing trying best we could to identify the multiple particular nuggets that are in this case. What I'd like to focus on in my presentation, other than questions that you may have, are one, there's severe error in the interpretation of the trial. Number two, the next category is the judgment and injunction that was granted absolutely runs against the rules 683 in the case law of what is permissible under an injunction. So if I may begin over with the first part, what we've got is the trial court took testimony. Plaintiff's case was based upon the testimony of one of my clients
They called him in chief. One of the neighbors, who was the one that engaged in that conversation, and then the developer, who testified to what his personal recollection was of what he was intending the deed restrictions to mean 30 years prior. It's completely wrong. The law requires the trial court to stay within the four corners of the document. And what we argued during trial, as far as the defendants, was in our response, in our answer, we briefed extensively. Number one, to stay within the four corners. Number two, the draft language of these restrictions is really poorly drafted. You've got two main deed restrictions, number one and number two, which were the primary focus of the presentation for everybody. And everybody's brief has agreed that number one, which says for residential purposes, the Supreme Court's cases of Tarr and J.B. Bryce clearly say that that means, hey, look, you got to use it for residential, not as opposed to commercial. That's all that does. And one of the things that the trial court, let me go back. And then number two, it goes through and it talks about there very archaically that you've got family can live in the residences, their assistants, and their servants. And it goes through and it has this weird language of a lot other than the one used by the family can be used by servants and assistants. And then that's in the first sentence. And then it goes on to, hey, look, you've got to have any assistants and servants connected to or within the primary residence. So the second part I submit to you, just as we have in our briefing, that basically that comes down to whatever your lot is. Deed restrictions do permit a house to be built on 2 lots, but wherever your house is, and whatever you're considering your property, you only have one structure. That's what that second part means. Now, that's important here because that second part is talking about structure. Part of both rights. Very clearly said that, hey, look, you've got this design structure type of restrictions, and then you've got your usage type of restrictions. So inside of that function would be in regards to usage. So that usage really where we said it all the way through this, if you look at the language in the 4 corners, that particular one says family. Now, we go back to the couch case from 1951. The Supreme Court came in, and the Supreme Court in that case considered a nuclear family definition that was submitted to the jury. And the Supreme Court specifically disapproved that definition in the jury instruction and came back and said, this is the Webster definition, and we approve that. And that particular definition included borders and renters. So as I briefed and presented to the trial court, just as we have in our briefing, when you read that second paragraph, you've got the inclusion of borders and renters. So the trial court came back, and what the trial court did in its interpretation that's absolutely just wrong is you look at the judgment in multiple places, and it says that the deed restrictions restrict a single family residence. But yet in the deed restrictions, there is no single family residence either. What the judge did, is the judge consolidated 1 and 2 residential and single family from down here, and then they tried turning it into something that it completely couldn't mean, because those two have to be read separately. You read restrictions to make sure everyone has a purpose, but yet you have to read each one independently and apply it. So therefore, what they come in the result of the judgment is that, hey, look, we've got a nuclear family. So what this means is this is a particular restriction that allows only a nuclear family plus any bona fide servants and assistants. So that completely goes against couch in regards to the definition, because if that was the purpose that the drafters of the deed restrictions wanted to do, they could have included a definition saying family means nuclear family, and that's been permissible.
Council,
Yes,
one, I'm gonna ask you to turn off the mic and see if it improves the audio any.
we all do.
Oh, it is off? Okay. Are we good on the volume? Okay, we're all good in the back, so maybe that'll help. But with regard to the two provisions, the first provision seems to be structural, and I'm not sure I follow what you're talking about with regard to how the trial judge's judgment reads. But if the first one is what I would characterize as a structural restriction, is there any question that the structure that is built on the lot or lots complies with a single structure for residential purposes?
There is none, and everybody's knowledge it's used for this.
Okay, so why does that impact the judgment as presented?
Because number one is the only place you find it on residential. So in other words, number two comes back, the judgment says it's for a single family residential use. So what they've done is the trial court has combined, and if you look at the effect of what they've done in their injunction, the trial court's come back and the trial court is trying to say a single family residence. So in other words, a nuclear family residence, not two.
But the trial judge didn't use nuclear family.
The trial court did not use nuclear family.
And so you've got a residence
Yes, sir.
for living purposes, for quarters, a place to live. But how is what the trial court did violative of the second deed restriction?
Because even if you look at the argument from opposing counsel makes the whole issue about it. You're not permitted, you're permitted. Yeah, if you look at the trial script, it opens. We have.
But in context, wasn't that we don't have a problem with renting the whole structure?
But that's not what the limitation is within the deed restriction. Because, I mean, simply the fact that in and of itself, if you take, there's no definition of family. So we have to defer back to, and when you take family includes boarders and renters. So therefore, renting has to be.
But that's based on the language of the restriction in couch. We have a different restriction in this chain of title.
I would submit to you that if you look at the restriction as the Supreme Court did in J. Rice, and that this one lines right up with the same type of interpretation and the same type of interpretation that this court did. So if you take, I don't know if you have questions. So
I have many, but I'll let you go on.
Well, the big thing about the Cockrell was you didn't have an owner who was living in the house. They had their sons, but they were the owners. So I mean, Justice Davis, in his opinion, clearly did a brilliant analysis of this going through. It's the best case that I've seen, period, in regards to how we would evaluate incidental, which that's another one. But still, even in Cockrell, where you have more definitions, you have better drafting than this little poorly drafted. And this court came back and said, incidental reading really has to be permissible.
Well, in this one, if the incidental renting were people who were assisting or servants of the other individuals living in the residence, then we might not be here.
Where it's interesting, because the definition of family includes renters and boarders. Assistants and servants is not a limitation on family, it's an addition. So what we have is we have a definition of family, which includes renters and boarders, at least incidentally, plus assistants. And so in other words, if we take within the four borders, the proper interpretation would have been living quarters on a residential lot other than the family, meaning a household including parents, children, servants, and as the case may be, lodgers and boarders. The principal residence shall be used only for bona fide servants and assistants. Such living quarters shall be within the main residence.
Well, you pop in words that I didn't see. I saw servants and assistants, bona fide, but I didn't see borders.
The definition that the words I pop in was the exact definition approved by the Supreme Court. They said this is the definition.
But that was one thing. What it was we have in this particular case, that anyone who would be standing there would be servants or assistants.
Not necessarily. So because just as in Cockrell, Justice Davis recognized that in that restriction, family wasn't. You have to go. It's from the Supreme Court.
This may sound like an esoteric question, but do we define family as the Supreme Court has subsequently construed it, or as the parties intended at the time the document was drafted?
If you're going to go with the title, well, first of all, you have to go. And so therefore, when you're looking, there is no definition. And if we're going to look at what's done, we have to know, just as this court has ruled, that whatever type is type of context, this court had just issued couch a few years before these different deed restrictions in 1996. So Attorney Sheehy.
Cockrell's definitions were done in 96, or these were done?
Restriction for 96, Cockrell was in that. In Cockrell, this court echoed the 1958 couch definition of family as including boarders and renters. So therefore, when the deed restrictions did not include anything else, in this appellate district, the recent holding from this court included or echoed that definition that statewide. And the attorney drafting, everybody's acknowledged. It's in the record. The attorney Sheehy drafted. It was an excellent attorney, a premier attorney. And that attorney had known that if you're drafting deed restrictions, you want something other than what's in the plan, just simply put it in restrictions.
So your contention, which I'll be honest, I had not picked up on this distinction from your briefing, is that the word the family in the second deed restriction would be construed to mean the family, parenthetical, members of the family, and incidental boarders and renters.
Yes, sir. In my briefing,
And therefore, we don't even need to get to the question of whether or not these incidental boarders and renters provide assistance to the family, or they are bona fide servants of the family.
that is correct.
Okay, I may finally understand your argument.
And so you're taking that position because that was the definition promulgated by the Supreme Court in the 1950s case. Is that correct? And, right. And we did it in Cockrell also. But I mean, I'm just curious. they applied a dictionary definition of family in Couch. Do you think that that definition should be changed as the dictionary definition changes? Because that's what the Supreme Court, they defer to the dictionary. If the dictionary definition changes, are we to move forward, or we stay with the 1950 dictionary definition of family?
So it's an alternative. And where we support the change. So if there was going to be an argument that this could be a change, then one reason should. Here's being the argument. I just said, this is supposed to be for words. You can't use parole evidence when you're going through deeds and stuff. So, I mean, one of the big things, Judge, is if anybody is going to go out there and buy a house, they should be able to go to these deed restrictions, pull them up, and say, hey, look, we're not permitted to do this. But yet, in this case, to turn around and support the argument that, wait a minute, these deed restrictions don't permit this. They didn't argue based off the language. They had to go pull Mr. DeWall, who was the guy, thank goodness he's still around, but who's the guy who developed it 26 years ago, to come back and say, this is what I meant. And any subsequent purchaser who's supposed to be able to go and be on notice, that's the whole idea, constructive or actual notice. And to be on notice, this is not permitted. Wouldn't be able to do it.
So because the restrictions in this case refer to family, your position, I guess, is that if they use the word family, everybody's on notice that family means what it means in Couch and in Concord.
I think we got transfusion. We were going to talk about family. I mean, traditional families were struck down by the Supreme Court, the United States Supreme Court. I mean, it's today's world, the nuclear family definition. Then when it, Christian, Judeo-Christian nuclear family. So we'd be more expanded.
Hold that thought. I'd like to give him 3 minutes to talk about the injunction issue. 3 minutes on just the injunction.
Thank you. Okay. So number one, an injunction has to be specific. Okay, it's got to be clear and concise. So this particular one, if you come back and look at the judicial declaration. So there's the first part, which is like 3 lines, the declaratory judgment, then a bunch of the injunction itself. What you find is basically they just recite the restriction. I mean, so in other words, the person is supposed to be able to look at the judgment and say, I can't do that. I can't build a fence 6 feet, my fence is not permitted, or something like that. Well, what they did is they came back and they said, we find that, it's, I hereby declare it's unlawful to violate the restrictions. Well, I mean, there's restrictions talking about it's permissible, number 4, talking about it's permissible to sign out 1910 square feet to rent. So, I mean, there's all sorts of regulations within that particular or any set of these restrictions. So the declaration absolutely didn't get clear. But then when you get down to the injunction itself, it's the same type thing. And one of the big problems with the injunction is the injunction terms. And the injunction includes successors and assigns. And Rule 683 specifically limits by an injunction can only go to parties that are in the proceeding. Case law is very clear. You cannot include successors and assigns. You cannot take an injunction and you cannot go, it's not an in-rem proceeding. It's an in-personal proceeding. And successors and signs means it's running with the land. It stays with the land. And that judgment can't be against future purchases, which and what that in theory does and can do is, hey, look, we're trying to sell a house and now suddenly you've got a cloud or a title or some unknown because of the judgment that impacts the marketability of it. And it's not supposed to do. An injunction is supposed to be limited, an extremely limited thing to that. So that's.
Council. Council, you may proceed with your 3 minutes.
This is actually a case probably because one of the biggest things in important as well in the United States individuals is their home. One day, you may be in a position to buy a home. You're going to decide things, you're going to decide what you want for your situation. One of my 26-year-old is on the east side of New York living in an apartment. Or you want to be where these folks, my clients, wanted to live, raise families in the country. In neighborhoods of land developments, and in this case, it was formerly such as this, when we're the subdivisions in McLean County. And he put on restrictions because he knew it was important for people to have restrictions that were protecting their use and enjoyment of property. And in this particular situation, he put on, there's 3 actual things. There are 2 use. And one is it has to be used for residential purposes. And it is. It has to be a single residence dwelling. And it also has to use the family. Remember, it talks about this is going to be a single dwelling, but contemplates that the family. You can only except for bona fide so we use SB1 family, the family. In this case, these folks bought this house, and this is not some simple deal where, oh, goodness, grandma needs somebody to help with it. These folks own 4 houses in McLean County, within which they currently rent, which would have made 5 houses with up to 20 rooms. That they would rent to several individuals. They've done this in previous states, and it's an interesting business. Nobody falls in. The issue is the covenants. This isn't something to show up at who's reading on the channel. Buying these restrictions and covenants are part of the deed, right? When you buy it, knowing that there are limitations. If you want to have a business like this, don't buy somewhere else. If you're protecting that policy, it's something like that. Do this. They can put some kind of a boarding house.
Council, you may proceed when ready.
I would submit that whether or not you can agree to, which is what a covenant is when you buy into it, you're agreeing to buy covenants. Can they do that to protect their investment, their way of life, their quality of life? And in this case, I think we have to understand what was going on in here. This is not, oh, hey, we're thinking about doing this. This is a business that they run. Nothing wrong with it. They've got 5 houses in Wayport, 4 houses in Wayport, 13 rooms. They're renting to various individuals. Very novel. They rent to people in town, let's say an executive that's running, building a hotel or renovating the building, or someone that's coming into SpaceX specific. They're in there for like a 6-month project, or 3-month project, or a 9-month. And so they get a housing allowance. They're not going to buy a house. They're going to rent a house, rent somewhere. And so they come up with the idea, hey, there's a market. There's a market. Because we, you know, and there are good tenants who are going to be here for this. It's a way to get around. The city of Waco, for example, has a short-term rental deal for Airbnb and that kind of deal. If you go over 30 days, then obviously you don't have to get a permit from the city of Waco. If you ask for a permit from the city of Waco, people in Stone Creek could go before the council and object. This gets around all of it. And they knew, it's clear from the facts, we got to understand that they knew what to do. This idea, oh, well, what we're going to do is we're going to say SpaceX that people are going to look out for the money.
Well, see, Council, that's where I was thinking this briefing was going, but the argument that I've heard today is that no, that the word, the family, used in the second restriction covenant is that what that really means is we've got the family and any incidental boarders and tenants.
Right above it, one sentence above it, I'll talk about that in far and other things, but right above it, sentence above it, it talks, and it's also constructible too, but it's single family, right? So the fact that it says the family, I think has to be given some intent. It doesn't say a family or so it's talking about the family, what family, the single family, the residence. Because Josh used to practice, you got to put all these things. So I think that is one way to address that. You have to give meaning to the use by the family. Now, we also look in all these cases where they're talking about this definition of family, they also talk about the primary purpose, right? And whether or not it is a commercial purpose, a financial purpose, whether you have, you know, for example, I think an argument at a trial where you're saying that, you know, you can't have a student, you know, foster kid and contributor, this kind of deal. That's clearly incidental. But if you look, for example, going back to looking at the terms, and the court asked about the 2 Supreme Court, the Supreme Court cases, I'm not sure well, and the rest of it, you know, you've got these separate things. You've got structural and residential purpose, right? They're not tied like in this one, where you have this separate thing that talks about the use for residential, but also the use for the family bona fide. And again, that goes to this issue of SpaceX. Bona fide. It's not, oh, we're going to bring around the students. And so I think that the charter, the way it was okay, residential use and structural single family. But our restriction adds another element. It says use as residential, structural single family, and the family and family and bona fide servants are the only ones allowed to use it. So use is addressed twice. In Vice, it specifically talks about tenants, right? Restriction says tenants, it contemplates tenants. So I don't think that helps. You go to Couch, which talks about, as this court talked about something popular, Southampton versus Couch, you look at the nature and extent of the use. And what is that? The evidence, or as a matter of law, establish. And it says if it's a rooming or boarding house, that's primarily for financial purposes as opposed to residential purposes. And that's exactly what we have. I mean, this whole concept, I mean, they're going to turn Bill Baxter's house into a boarding house. And if they can do that, they can make a foster house. You know, 7 different families. They can make it a house. There's nothing wrong with those facilities, but when Mr. Dewald set up Stone Creek, And I would venture to guess Hidden Valley and Twin Rivers, and we'll see this. And what will do is blow a hole in these neighborhoods, where all of a sudden you can have a house, half a house on the street. You just rented all these rooms, and we say, oh, well, under this other case, they're family, just because they're under the same roof.
One question, you mentioned Mr. DeWalt, and I know he testified in the matter. Aren't we really bound by the terms of what Mr. Sheehy drafted, not what Mr. DeWalt thought he was doing?
Cases. The tar is discerning the draft's intent. It does say you look at the language, but in this case, what Mr. DeWalt said is exactly what it says. We thought it was important to kind of common sense does tell us, I guess, the record does common sense, but these neighborhoods are set up for a purpose to create quiet, single family neighborhoods where people raise their children, it's higher, that type of thing, and not to go into whatever there's boarding house. My house in Session, I have 3 upstairs bedrooms, and my kids have all graduated. It's not what anybody contemplates, and this is just content within the land. The fact that, you know, they started out with this concept of this space next to anybody can do this. And that's not what's contemplated, and that's not what this language means. If you're going to give intent, for example, for the families, it refers to the single one, that's the structure and the resident.
Council,
And there's no point if servants and assistants are definition, as a matter of course, they're under the roof. Why do you use, why is there that? Why do you add, oh, you know, if you can have servants, family, anybody you want to rent it to, then why did Mr. Sheehy single out that you can have a caretaker there? Because he obviously addressing the family doesn't need everybody.
Council, I want to reach back to the J. Bryce case and your interpretation of it. You said something about it has a use component and a structure component, and that they sort of came together on the use.
I was being hard to the course of government.
Okay.
That's what I was trying to explain. With Bryce, I was pointing out that the restriction specifically includes for the owner, his family, guests, and tenants. So Bryce, the deed restriction specifically contemplates that there will be tenants.
Okay. And maybe this is too fine a point at this stage of the argument without me having studied those cases more closely, but it seems to me that the second restriction covenant that we're looking at focuses on, or at least mentions, the occupants as a potential third distinguishing factor. The use as a residential, the structure as a single family dwelling, and then who are the occupants of that dwelling, and it restricts it to the family and assistants and servants.
Which to me is who can use it, as a resident.
Okay.
I think that paragraph 2 of restriction is a use limitation. So you've got use for residential purposes, a single family structure, and that. And there's purpose only. We talked about couches really the case that focuses on the issue. Very clear that it's a room in a boarding house. This one, not, says, so one not a home for occupancy. If the home is being used primarily for finance, And well, Stephanie told me they were.
So you think this falls under the exception mentioned in Couch, even where we recognize incidental, that this crosses into the threshold that Justice Davis had discussed?
Totally blows through. This is the only way they can try to get around conditions. As far as speaks for itself, I will say that there's two other cases that I think are, worth looking at. We're citing that tar sites, permanent masonry sites, the Chamber case, which is an Amarillo case, and talks about they were trying to put in a group home in Chamber, and it talks about use and those types of things. But the cases that they're the most big on, tar and ice, I just don't see as saying what they're talking about. Now,
Counsel, you didn't cite those in your brief, did you?
You know the rule,
Permanent masonry cited tar and permanent masonry sites.
I know your co-counsel is familiar with this to follow up with citations.
Issues, and you would ask the question of respond.
I guess technically y'all are not co-counsel since y'all have different clients.
That's true. That's true. We are going. Good morning is one way. I will call it on two of the other things that we two of the neighbors. I want to just point out the way I was just reading this. Which is this deed restriction. The argument has been more, and Chief Justice Kirby said, I finally get the argument. I finally understood what was going on too now. I think we heard it. And one of the reasons for that is that we had a constantly mortgage market. First, they weren't going to rent it home. Then they were only going to rent space as executives. Now we've got this new argument that family means something wildly expensive. So I want to particularly address just that point. The court says, yeah, maybe family could be incidental fringe. First off, defining family as something diametrically opposed to family is something that is slightly at odds with the intent of God. And second, what I want to point the court to is exactly what this court noted in Congress. That was not the last opinion. There was an opinion when we hear it, where the Supreme Court cleans up some of that language. And here's what they specifically said. They say, if the evidence establishes a matter of law or the trial court functions, conflicting evidence, that a particular defendant is operating a roommate or boarding house on his premises, or is renting space other than the dwelling as or is using a dwelling house as a primary source of financial gain, rather than investments for himself and his family and investment service, that activity should be enjoined. That's not the court noted that. You're right now too. Yeah, times. The theory was that this is going to mean so working fellows live there, 6 other rooms will be rented out. That's not incidental. That's not any construing couch and these employees. That is not restrictions. The second issue, which I will touch on here, is the issue of rights. Certainly, that's a threshold that we this court has to give up. I want to do that relatively quickly in just about 3 parts. First, what is rightness? Second, why this case certainly is right. And third, and finally, just note one quick case on restrictions. Courts have noted that particularly
In declaratory relief cases, the question is simply this: is there a justiciable controversy that will be settled by the requested relief? And what that means is not that there should be some has actually occurred. It doesn't actually have to be an injury. And for good reason, right? We don't want SpaceX executives to have to move in. We don't want the construction to drive in. We want to go ahead and jump in before there's been this kind of thing. And so what the Supreme Court of Texas has told us about 2 years ago in the Southwestern Electric Power Percentage is that these declaratory relief cases are often brought in towards the future. One of my favorite phrases in this is, oh, we need to be looking like the companies. And the nut of this analysis is, would the declaratory relief sought provide some resolution to the parties' dispute? And that basic notion tracks precisely what we see in the Uniform Declaratory Judgment Act. That under 37.004, plaintiffs for a written instrument, including deed restrictions, can figure out what the rights and obligations are before or after. 37.002 tracks that, saying that the purpose is to inform the relief concept. So let's drop our facts and legal facts, right? Here's what we know: 3 things. The appellants testified that this case would dictate how they use the property. Page 39 of the second line of the reporter's record, when the appellants specifically asked, if you want to use this property to rent to SpaceX executives, yeah, before it lets them. And he says that whatever happens here is going to bind me, and I'm going to understand those are my rights. Second of which is, again, this notion that this was just some abstract, far-off thought. Maybe we'll rent in the future. Record bust that several times over. They knew exactly who they wanted to rent to, SpaceX. They knew how they were going to reach out. They knew roughly what they were going to charge them, and they knew that approximate monthly rental revenues. This was not just about people. This was part of the existing quote business model. They had 4 other homes that were generating up $10,000 to $13,000 a month, doing exactly what they were doing here. This was not just an idea. This was the find is their own pleadings. Right? We have 2 claims for their own pleadings. First of which is tortious interference, in which they said, you plaintiffs are interfering with my right to use the property. Not just that, I'm being harmed now and have been harmed in the past 3 years because but for your conduct, I would be using it. No, they're telling us exactly what they would do right through that now. It's lawsuit. The second is the request for the court. Obviously, is just I want to look back quickly to that Southwestern Electric Power case. Where another day, parties underscores the existence of this. And so in this record, certainly one last thing I would know, and I will submit this also in the post-session brief, is this court's order is a recent case involving restrictions. Then, of course, this court's opinion increased versus the next five. It dropped about a month after we filed our echoes brief on that case involved potential violations of deed restriction and questions of rights. This court resolving exactly that dispute said, no, we don't have to wait till the actual land outfitters and adults and people. It's going to not be a justiciable dispute about these deed restrictions, what they mean, and dictate the course of conduct. And so both from a rightness analysis and ensuring the couch, subsequent court is corrected, we request that this court should affirm the trial court's judgment, give meaning to these restrictions, and implement what the proposed intent.
You've got almost 30 seconds left to address the injunction scope. Please.
First of which is the issue of preservation. You might have heard about it. There's this sort of end run that, oh, we didn't have to just injunctive relief is a use of discretion statement. We need to tell them. Second of which is this permanent injunction is going to dictate future how this is used. It's an appropriate use.
Thank you, counsel. You have 5 minutes for rebuttal. If I can get this.
First of all, paragraph 35 of our original specifically includes the definition. This idea of reading more stuff is absolutely crazy. If you look at our pleadings that were out before the trial court, it's the sliding run. Second of all, I'd like to give real quick Jay Rice. Jay Rice specifically, it does talk about students. but the parking tenants, and it's not a parking lot. That deed restriction specifically said, permit the same or any part thereof to be occupied or used for any other than a single family residence or the pool. That's what it says. It says for the owner, it says single family residence, but yet here in the next paragraph, the Supreme Court comes back and says, we've held use is a construction issue. M.J. Bryce with single family residence, the Supreme Court came back and lined it right up with it said these are the same. So the idea of single family residence, here it said by the way, but yet J. Bryce was an LLC owning the property, renting out stuff. Clearly a single family owner, an LLC is not family. So the owner wasn't even a family and they were renting. So that was held to be structured, period. So the idea of coming back and saying that single family residence as used in these deed restrictions can come back and mean that is incorrect. Pursuant to J. Bryce and Clark. Coming back to Southampton, First Couch. That was somebody who had a residence in the 50s, nuclear family who mom staying at home and they're renting out rooms to my students. Incidental, somebody not related, somebody kicking in over me, somebody, I feel here that these homeowners, if they allow somebody else to come in and be in their house, the people that come in the house can financially contribute. That's absolutely crazy. The idea of whether it's across the threshold, if we're looking at incidental, whether it's across the threshold of incidental to a commercial purpose, that has to be satisfied by the facts. And the only facts that the team is presenting, Mr. Burke can't get another thing. Middle of the street, they said, ran out. They get the business model, which is a business model. They come back and they said, hey, look, the market is 60. And then they turn around and they said, hey, just so the idea in this case, some high, nice to meet you out in the middle of the street, somebody saying, yes, we've got a plan to rent X SpaceX people and make $9,000 a month. That's clearly as far away from some concrete plans you think you have to wait till the points. But at least when the building's going under something, these folks have, they hadn't moved in. They had just closed. These people, these neighbors wouldn't know somebody moved in and moved the truck and everything else. The testimony here comes back and shows that they went right away to a point. These people got a letter from the point, and then they turned around in the middle of COVID trying to secure a lawyer to help them guide them through this. They had time trying to get an appointment before they even got their appointment. They're getting the second letter. And before that lawyer could even give them a research and an answer or correspond with Mr. Dixon sending one, I mean, a lawsuit. So, I mean, the idea of somebody moving in here and just having a nice to meet you conversation in the middle of the street to coming back from that and saying a month after they closed to move in that, hey, look, you're tearing up and ruining our neighborhood. They just want the biggest fans. And I mean, so the idea that we're going to have this thing, the 7 bedrooms, parking to accommodate everything that Mr. Packus did for his entire family to be there. But if we let somebody, like a student, and text a SpaceX person, just somebody with a random person come in, well, that can't be permitted. Much less, part of the rightness in this thing is they argue that, hey, look, there's no way that SpaceX people can qualify as an assistant or a servant. You can find both. I completely understand it is cheap. Said in medical on the cross, Mr. Burkett, if you're talking about that, do they have to be dealt with? RN, do they have to have any sort of certification? Is there a specific duty set that they have to do? Do they have to?
Wrap it up, council.
Nobody has anything, and so therefore, that's why there's the likeness issue or mootness issue, because by the time the testimony came down, they specifically said, one of the reasons is already
Thank you, council.
charged.
Okay.
Thank you.
This case is submitted and y'all are excused. And we're gonna adjourn until the 1:30 docket.